there is one role that stands out in helping organisations stay compliant with the GDPR, it's the Data Protection Officer, also known as the DPO. But what exactly does a DPO do? Do you really need one? And what happens if you don't appoint a DPO? Let's navigate through these questions together. A DPO is an individual or entity responsible for advising an organisation on its data protection obligations under the GDPR. But the role of the DPO goes beyond just ticking a box. A good DPO can transform your organisation by bringing an organised, efficient and expert approach to data protection compliance, saving time and resources for other commercial priorities. A DPO's key responsibilities include advising the organisation on its GDPR compliance obligations, monitoring compliance with the GDPR and internal policies, conducting audits, raising awareness and providing training, acting as the main point of contact for both data subjects and regulators, assisting with personal data breaches, data subject rights requests, and advising on data protection impact assessments. And of course, cooperating with supervisory authorities. An effective DPO helps create a culture of compliance, enabling the organisation to focus on other commercial and strategic objectives. How do you know if you need a DPO? The GDPR sets out 3 triggers for when a DPO must be appointed. These triggers are as follows. 1. If your organisation is a public authority or body, such as a local council, government department, regulatory body or similar. 2. If your organisation's core activities involve regularly and systematically monitoring individuals on a large scale, for example, tracking behaviour online or via CCTV. And 3, if your organisation's core activities involve processing large volumes of special category data, for example, health records, political opinions, or biometric data, or information about criminal convictions or offences. While the term large scale isn't defined, you will need to consider factors such as the number of individuals involved, the volume and type of personal data processed, and the geographical scope of your processing. Even if you do not meet the requirements for appointing a statutory DPO under the GDPR, you can still voluntarily appoint a DPO. But remember, if you choose to appoint a DPO voluntarily, the same GDPR requirements will apply, including the need for the DPO to act independently and have the necessary resources to fulfil their duties. If you carry out an assessment and decide you do not need a DPO, you do not have to appoint one. However, make sure you are confident in your decision. If it turns out a DPO was required and you failed to appoint one, you could face a fine of up to 2% of your global annual turnover, or around £8.5 million or €10 million, whichever is higher. And don't forget to make sure you keep a detailed record of your decision not to appoint a DPO, in case you need to justify your rationale to a regulator. The role of a DPO is more than just a compliance requirement. It is a vital role that can make a significant impact on your organisation. Whether required by law or voluntarily appointed, having a DPO can help guide your organisation through the complex terrain of data protection, ensuring security, compliance, and trust with individuals when you use their personal data.